House Committee on Natural Resources, Environment, Tourism, and Outdoor Recreation will come to order. Will the clerk please take attendance?
Chair Pohutsky.
Here.
Representatives Hill.
Here.
Shannon.
Present.
Arvid. McFall.
Here.
Ties.
Present.
Martin.
Here.
Preston.
Here.
Shriver.
Here.
Madam Chair, you have 8 members present. You have a quorum.
Great, thank you very much. Representative Shannon moves to approve the minutes from our previous meeting on October 5th. Hearing no objection, the minutes are approved. So first up on our agenda, we are going to be taking testimony from Rep. Rogers on her substitute for House Bill 4832. Once Rep. Arbit gets here later, we will be voting on that, but I know that you have committee to get to. So if you wanted to have the floor, Rep. Rogers, it is yours.
Thank you so much, Chair. Good morning, members of the Natural Resources Committee. Thank you, Chair Pohutsky, for allowing me to share this H3 substitute to House Bill 4832 today. After testimony on this bill a few weeks ago in September, a few stakeholders reached out to our office to work on language to clarify the intent and ensure that nothing in the bill would exceed the Department of Environment, Great Lakes, and Energy's authority to act in regards to Federal Energy Regulatory Commission, aka FERC, regulated structures. The language included in the H3 substitute reflects agreement between EGLE, the Michigan Manufacturers Association, and other utility companies. Specifically, the substitute revises the bill to say that the legislation does not, I repeat, does not expand the department's authority under Part 315 as limited by Section 315062A. This negotiated language preserves the intent of the bill and provides EGLE the authority necessary to ensure that man-made ecological disasters, such as happened in the Kalamazoo River, are prevented, and if not, that the responsible party is held responsible for cleaning up the mess that they made. Thank you again for your consideration of the substitute, and I welcome any questions that you may have. And also, we have Jared, legislative liaison, here to answer any technical questions.
I have one question, Rep. Rogers, if you can speak to it. I know that we had some folks who were opposed previously. I believe their positions with this substitute have changed. Can you cover that for us?
Yes, everyone has gone to neutral, and I do not have any knowledge of anyone opposed to this.
My understanding, I don't have a card, but I just wanted to be as clear as possible based on emails we've gotten that both MMA and the chamber are now neutral because of this. Okay, great. Are there other questions anyone has? Rep. Shriver?
Why does this amendment, why does it give EGLE authority to issue an order to any person and found in violation of this act? Why not just the dam owners?
Because you may have situations where there is a person, the person could be the dam owner, but it gives a little bit of flexibility for other, people that may be responsible parties.
Are there any questions? Thank you very much, Rep. Rogers. Okay, we will be coming back to both the adoption of that sub and taking a vote on the bill itself. But next up, we are going to take testimony on Senate Bill 441, which has been sponsored by Senator Schenck. So at this time, I would like to invite forward Richard Williamson from Senator Schenck's office. And the floor is yours.
Thank you, Chair Pohutsky, Vice Chair Martin, and members of the committee for having me here to testify to SB 441 on behalf of Senator Schenck. Like the chair said, my name is Richard Williamson, and I'm Senator Schenck's legislative director. She regrets she could not leave session to be here, but appreciates that you're considering this bill. SB 441 amends 2 sections of the Natural Resources Act that concerns fishing in the Great Lakes to ensure the state of Michigan is in compliance with the federal court decree between the state and the tribes. That decree requires that the tribes and the state share reporting information on how many fish are harvested out of our Great Lakes. In order for Michigan to meet its end of the decree, SB 441 is required so that the DNR has the ability to collect catch activity reports from commercial fishers, charter fishers, and fish wholesalers operating in the Great Lakes. I want to note that this legislation does nothing more than bring the state into alignment with the requirements of that decree. The decree has been in effect since August 24th of this year, and it is important this legislation be passed so the state can meet its requirements as the tribes are currently. Thank you for allowing me to testify today. I'm happy to answer any questions, but of course defer to the DNR on any specific questions.
Are there any questions that anyone has for Richard at this time? Rep. Shriver?
Are you able to express what the economic impact of this law would be?
With that, I'd rather defer to DNR since they've been working on the consent decree and with the tribes on the reporting requirements.
There's also a fiscal impact statement that was put forth by the Senate, too, if that's helpful at all, in addition to what the DNR has to say. Are there other questions? All right, great. Thank you very much, Richard. Next up, we are going to have Scott Everett, who is representing the Michigan Fish Producers Association.
Thank you, Chair, members of the committee. I'm Scott Everett, here today on behalf of the Michigan Fish Producers Association that are made up of the state licensed commercial fishermen. There's 13 of them, categorize them about 10 full-time state licensed commercial fishermen and another 3 that are full-time, they say part-time. Part-time 10, another 3 that are full-time. We're opposed to House Bill 441. The consent decree, important to understand, is an agreement essentially between the DNR and the tribal commercial fishermen that apply to the 1836 treaty waters. It has nothing to do with the state licensed commercial fishermen. The state licensed commercial fishermen oversight are you, the legislators, and the law. So the agreement does not apply to state licensed commercial fishermen. However, this agreement, language did show up in this consent decree, essentially requiring Senate Bill 441 to give the DNR the authority to carry out new regulations on state licensed commercial fishermen. And in 441, they're proposing to do that by order, giving the DNR the authority to do orders to require anything they want, anytime they want, from state licensed commercial fishermen, and we're very opposed to that. We have 3 suggestions. I've submitted written testimony to the committee, and I'm not going to read it to you, but we've got 3 suggestions. Number 1 is don't pass 441 at all. That would require the DNR to go back into the consent decree and remove the language out of the consent decree concerning the state licensed commercial fishermen and what they promised to do that they didn't have the authority to do. Amend 441 by striking the ability for the DNR to do orders. That would then require state licensed commercial fishermen to report electronically every 14 days instead of every 30 days like they are today. State licensed commercial fishermen really don't like that, but they have admitted that they could live with that. And then finally, and the logic of this is I think apparent, is that if you're going to give the DNR the authority to do orders on state licensed commercial fishermen, that should be limited to 1836 treaty waters only. So those commercial fishermen that are fishing in 1836 treaty waters would have this requirement, and those that aren't would not. And so with that, Madam Chairman, I'd be happy to answer any questions.
Do we have any questions for Scott at this time? Or Trevor?
Was your feedback taken into consideration at all during the drafting process of this bill?
Sure,
or is
we
this
had meetings on it, and absolutely, yep.
And did they express kind of any plans for integrating the feedback that you were able to give them, or work with you, or was it kind of more of a stalemate?
We'll call it a stalemate because the bill has ended up here. I think it's a process, and I think they did give us the opportunity for input of the bill, but it didn't change. With our main concern, I want to be very specific about this, is giving the DNR the order authority to require anything they want, anytime they want. There's nothing in the bill that, in terms of outlining what the reporting requirements are going to be.
Thank you.
Representative Pies?
Thank you, Madam Chair. From your perspective, what is the exact reason that they did it like this, that the consent decree was given by the court?
Well, so the consent decree process, I'm not sure I quite understand. There's confidentiality agreements signed during the negotiations of the consent decree. So there's no way, even though we ask a lot about it, there's no way to find out what they're all agreeing to until they submit the draft to the federal judge. And that happened, I'm going to say December or January, I can't remember. And once the draft is given to the federal judge, he then approves it. And that was approved on August 24th.
Are there any other questions? All right, thank you very much.
Thank you very
John.
much.
I appreciate it. Next up, we have joining us through Zoom to speak in opposition to the bill is Bill Winowicki, President of the Michigan Charter Boat Association. And the floor is
hear me
yours.
now?
Yep, we can hear you.
Okay. Well, thank you, Madam Chair and members of the Natural Resources, Environment, Tourism, and Outdoor Committee for the opportunity to testify on Bill 441. My name is Bill Winowicki. I am the president of the Michigan Charter Boat Association. The Michigan Charter Boat Association is in opposition to Senate Bill 441 as written. This legislation will eliminate the MCBA being a partner in the decision-making process. Under the present Charter Boat Act, the MCBA members have been doing the fish catch reports for over 40 years to support the department on the biology of the Great Lakes. The department now wants to remove the Michigan Charter Boat Association entirely from the statute and wants to cut the MCBA from any further discussions or decision-making on charter boat reporting. The MCBA was not consulted on the changes to Bill 441. The reporting system has changed many times over the years, with the department and the MCBA working together to help the department to improve the regulation of Great Lakes fisheries. The fish catch reporting started with lake trout and salmon caught on each charter excursion. The charters were then required to include how many people were on the boat, how many hours dock to dock for each trip. The department then added all species caught and released on each charter to be reported. The department then wanted all charters to report how many lampreys were attached to the salmon and lake trout. The reporting system started with the department requiring a paper form that was supplied and mailed out to each charter to be filled out and returned by the 10th of each month. The department then decided that paper reporting would be replaced by electronic reporting. The MCBA disagreed with this new requirement since it put a burden on some of our older captains who weren't computer literate and didn't have access to a computer. We went through the process and now everybody is on board with the computer reporting or online reporting. The reasons given for removing the MCBA from the Charter Boat Act, I've been told, is that we don't follow the act and there is no documentation stating that we did meet. I have pulled past MCBA board meeting minutes from Jim Dexter, past chief of fisheries, Donnie Westender, who is in charge of all the charter boat reporting, and other DNR personnel who have made arrangements under the Charter Boat Act to attend our board meetings. This gave us all a chance to discuss issues and voice our opinions or disagreements at time. Bill 441 eliminates this process. The MCBA represents over 400 small businesses in Michigan. The MCBA has worked with the department for many years trying to and improve our fisheries. We disagree with our removal in Bill 441. I would ask the committee to consider keeping the Michigan Charter Boat Association as part of the act. I'm going to throw in a little of my personal opinion here. You were just talking Tribe of the Cree. I was one of the core members involved in the negotiations with the Amici for the last 4.5 years. And all that is required with the Tribe of the Cree is that we go from monthly reporting to 2-week reporting. And the charter industry is on board with that. But there was no reason to take the Michigan Charter Boat Association out of the decision-making process and writing us out on this bill. And like I say, we were never consulted. So thank you, Madam Chair and members, for the privilege to testify. If you have any questions, please ask.
Does anyone have any questions for Bill? Thank you very much, Bill.
Thank you.
Next up, we have, I believe, testifying together, Dave Carafino, Taylor Ritterbush, the DNR, and Randy Claremont. I believe we're going to be doing a hybrid event. I think we have some people on Zoom, if that's right, Taylor.
Yes. Thank you, Chair, members of the committee. Again, I'm Taylor Ritterbush. I'm the legislative liaison for the department. And as the chair mentioned, we've got our Chief of Fisheries Division, Randy Claremont, online, as well as Dave Carafino, who was involved with the tribal negotiations. They're actually up in the UP today participating in the Natural Resources Commission, so they couldn't be down here in Lansing. But we appreciate you taking the time to take a look at this today. I want to address a couple of things that have been brought up. First, with the requirements that are outlined in the decree not being in the legislation. We did adopt a substitute on the House side that does include those specifics. So it says in the draft in front of you that the report shall be provided to the department with twice monthly catch activity reports. So that is outlined in the bill, and that has been addressed. And then secondly, to speak briefly to what the charter boat captains had just brought to your attention, that catch activity report committee was established in 1995 before catch activity reports were required. And that committee was brought together to develop those first paper reports, basically what is going to be required to be reported to the state. And after that paper document was codified or pulled together, at that point, the committee never met after that. There have been numerous venues where the department continues to work with the charter boat captains. As Bill pointed out, we attend their monthly board meetings. We also have division managers who attend their annual association meetings, and we also have a dedicated charter boat specialist that is employed by the department. So we will continue to have input from the charter boat captains. The removal of this is a committee that never met after it served its purpose. We also have representation from the charter boat captains on all four of our Great Lakes advisory committees. So that's Lake Huron, Lake Superior, Lake Erie, St. Clair, and Lake Michigan. Each of those lake committees have representation from the charter boat captains. So by no means are we looking to stop conversation with them. We're looking to move forward in working with them. And we appreciate their support of moving towards twice monthly reporting to bring us in line with the proposed decree. That decree was negotiated between the state of Michigan and the federally recognized tribes. And in that negotiation, a large part of that was information sharing. If we don't know how many fish are being pulled out of the lake, we don't know what kind of impact we're having. And so that was an agreement that the tribes and the state came together on and said, we need to know what the state is harvesting, we need to know what the tribes are harvesting. And so through that agreement, that negotiation, it was decided that twice monthly, those reports would come in and that information would get shared between the two parties. So at that point, that's when we knew that we needed to move in this direction to have that authority to require more frequent reporting. That is now a federal court order, and currently, as we sit today, we are in violation of that court order. I'd be happy to take any questions. Thank you.
Rep. Preston?
Thank you, Madam Chair. In the bill, why would you not limit these new regulations to state licensed commercial fishermen that fish within tribal waters?
Well, I think as the department has a responsibility for managing all the fish or all the resources for the state, it would be in our interest to know what's happening across the lakes spatially, right? Not just in those tribal waters, and making sure that we have a good idea what's happening across the lake that can provide for, potentially additional opportunities for commercial fishers outside of those 1836 areas, that if we now know where those populations are at, that could provide additional opportunity.
And how many state licensed commercial fishermen are now fishing in tribal waters?
Dave, do you have that number off the top of your head?
Yeah, currently we have five fishers that operate in 1836 waters.
Does that include the one that you eliminated?
That does not include the one that is no longer has an allocation in the northern part of Lake Michigan.
Can you tell me the disposition of that? or shed any light on what's going on with that? Because it directly relates to what's going on in my district.
I defer to Randy on that.
Yes, good morning. So the question is, in the standing decree and court order, one of the commercial fishing operations is no longer able or authorized to fish in 1836 waters. So we have changed the license provision so that that fisher is now fishing in an adjacent unit. And I can take additional questions or clarification if needed.
If I could just explain to the committee, through this new consent decree that we're talking about here, the DNR agreed to eliminate one of the 2 state licensed commercial fishermen that I have in my district. And they're now fishing in the same whitefish management zone that was exclusively fished by one of the individuals. So I'm just trying to find out where this is going and why there wasn't an effort on the DNR's part to compensate that license that got displaced through the consent decree, instead of placing them in a zone that's basically in direct conflict with established past practice as well as quotas.
I can just add again, this was a provision of the decree of the court order, but it does not pertain to this bill directly in terms of reporting. The reporting requirements are provisions of the decree. This move of this fisher will be glad to handle any discussions or questions beyond this hearing, but really the reporting requirements are, as Taylor mentioned, right now out of compliance with the decree, and that's what we're attempting to correct in this bill.
Well, I would appreciate some help because I've got a mess in my area.
Are there other questions? All right, thank you all very much. We do have a couple cards to read in, although they're both people that have already spoken. Opposing the bill, Scott Everett from the Michigan Fish Producers Association, and supporting the bill, Taylor Ritterbusch of the DNR. We are going to move back to 4832. I do have some cards to read in. Not wishing to speak, opposing the bill is Peter Riddell of Honigman LLD. And then not wishing to speak, supporting the bill, Sydney Hart and Gerard Sanders of Eagle. We will be voting to adopt the H3 substitute, and Representative Pies makes that motion. Madam Clerk, will you please call the roll?
On adopting the substitute, Chair Pudsky.
Yes.
Representatives Hill.
Yes.
Shannon.
Yes.
Arvid.
Yes.
McFall.
Yes.
Pies.
Yes.
Martin.
Yes.
Preston.
Yes.
Shriver.
No.
Madam Chair, you have 8 yeas, 1 nay, 0 pass. The H3 substitute is adopted.
Thank you very much. We will now take a motion to report House Bill 4832 as substitute H3 with recommendation. Motion made by Representative Arbit. Madam Clerk, can you please call the vote?
On the motion to report, Chair Pudsky.
Yes.
Representatives Hill.
Yes.
Shannon.
Yes.
Arvid.
Yes.
McFall.
Yes.
Pies.
Yes.
Martin.
Pass.
Preston.
Pass.
Shriver.
No.
Madam Chair, you have 6 yeas, 1 nay, 2 pass. House Bill 4832 is reported for recommendation as substituted.
Thank you very much. Seeing no absent members to excuse and there being no further business before the committee stands adjourned.